All right. Hi, everyone. Welcome to our training tonight. My name is Iris Wen. My pronouns are she, her, hers, and I am the FRC training coordinator. We are super excited to have Courtney Mingus, clients' rights advocate and staff attorney from the Office of Clients' Rights Advocacy with us tonight to talk about conservatorships and alternatives to conservatorships. First, I just want to briefly talk about what the FRC does here in San Mateo County. We serve families who have children with disabilities between the ages 0 to 22. We are staffed by parents and siblings of children and young adults with disabilities, and we provide support, information, resources, and referrals to navigate the systems out there. We also offer trainings just like this one, support groups, a resource finder, as well as a monthly e-newsletter. I want to give a disclaimer that the Family Resource Center is not a legal firm or a legal services agency, and we cannot provide any legal advice. Any information provided by the FRC should not be considered a means of taking the place of legal advice that must be obtained through an attorney. With that, I invite you all to connect with us, and I'll go ahead and put our contact information in the chat. I also want to introduce our FRC team who is here with us tonight. We have Patricia Idrugo, our FRC supervisor, and Sonia Valenzuela, our Family Support Services manager. Next, we just want to go over some general housekeeping items to make sure that this training runs smoothly tonight. First, we will be recording tonight's training for any families and providers who are not able to attend tonight. So we ask for your collaboration with the following guidelines. Please mute yourself when not speaking to avoid any background noise. You can have your video on or off based on your preference and comfort level, and we invite your respect throughout this training. We are offering simultaneous interpretation in Spanish today, so if you haven't already, please select the language that you would like to listen to the training in. You can do this in the settings bar under the globe icon and select either English or Spanish. We ask that if you are listening in English, please still select English in the settings bar, and this will allow you to hear the interpreter translate from Spanish to English as needed. We will also be having a Q&A portion at the end of the training. We ask that you please save your questions for the end. You can use the chat box or raise hand feature right here for questions and comments. We encourage you to refrain from sharing names or any detailed information to protect your privacy and other families' privacies. And after you ask a question, please be mindful of making some pauses to allow our interpreters enough time to translate both the question and the answer. At the end of the training, we will be distributing a survey, both in English and in Spanish, to collect your feedback on how this training went. There will be a survey for the FRC and then a survey for OCRA. The surveys will be anonymous and will help us understand how to improve our trainings to better serve you all. Lastly, we will be sending a follow-up email tomorrow with the materials from this training. Okay, and that is it from me. So now I'll turn it over to Courtney. Thank you, everyone.
Hello, everyone. Welcome to today's training on alternatives to conservatorship. Thank you all for being here. My name is Courtney Mingus. Pronouns are she, her, and I am the client rights advocate and staff attorney. So I'm actually a statewide client rights advocate, which means that I can serve any of the offices across OCRA, the Office of Client Rights Advocacy. But I'm currently filling in for the Golden Gate Regional Center full-time. So if you contact the Golden Gate Regional Center office, you would be working with me. I also, Giovanna Rojo is also in this meeting. She is the current assistant client rights advocate for Golden Gate Regional Center as well. I want to start off by giving a quick disclaimer and ask that because this is a public training, that you don't discuss any private or confidential information about yourself or a family member. There is no right of confidentiality here. We are also mandated reporters and must report when we have a reasonable belief of adult or elderly abuse. This training is not a private consultation for legal advice, and there is no attorney-client privilege. If you have specific questions about your case, you should reach out to our office. So what we're going to go over today is what are conservatorships, some terminology, an overview of the conservatorship process, and alternatives to conservatorships. And the reason we're going to cover alternatives to conservatorships is because the Office of Client Rights Advocacy cannot advise on conservatorships or help people file for conservatorships. Okay. So what is a conservatorship? So a conservatorship is just really any time where someone else is appointed by the court to be legally responsible for a person. It does take away fundamental rights from an individual. And conservatorships apply to people over the age of 18. When something like a conservatorship is held for someone under 18, it's a guardianship. This is how the terminology works in California. And conservatorships last until they're terminated by a court or a statutory occurrence. Sometimes they have deadlines. There are a few different types of conservatorships. The one that we deal with the most are limited conservatorships. There are 7 powers that can be granted for a limited conservatorship. There's also conservatorships that are granted by probate code. This can be a general or limited conservatorship of the person or of their estate. And then we also have what we call LPS conservatorships, which is the Lanterman-Petrus short conservatorship. This is reserved for people who are what the code calls gravely disabled and at risk of injury. And this is created by a psychiatrist or a doctor. And then there's also dementia conservatorships. This is similar to a guardianship, typically. We deal less with these ones, to be honest. We can go to the next slide. So some terminology, again, conservatorship versus guardianship. In California, the term guardianship, which a lot of people use interchangeably with conservatorship, actually only applies to minors, and conservatorships are for adults. All the time when you have a conservatorship, you have what's called letters of conservatorship. Am I going too quickly? Okay, hopefully I'm going slow enough. Okay, so when you have a conservatorship, it usually it will have you'll obtain a letter of conservatorship. These are papers from the court that are issued when someone's granted a conservatorship, and it lists the powers that a conservator has. If you contact our office with a conservatorship, we'll ask you to give us the letters of conservatorship. And then some other terminology, a conservatee is the person who is conserved, the person with a disability who's subject to the conservatorship, and a conservator is the person who makes the decisions for the conservatee. At a basic level, the law presumes that any individual, once they're 18, regardless of their disability, is capable of exercising their rights as an adult. So a conservatorship overrides this presumption, but everyone starts with the presumption that they're able to exercise their rights as an adult on their own. A conservatorship is established by a petition that is filed to probate court. Once it is filed, copies of the petition are sent to the relatives and agencies, the person who's going to be conserved. And then a court investigator interviews the conservatee. This is the person who's going to be conserved. And that interview is really just to see if the conservatorship is necessary. Then the regional center submits a report for limited conservatorship. This is if they're regional center clients. And then a hearing takes place. Conservatees attend unless they're out of state, medically unable to attend, or unwilling, and they don't oppose the petition. So these are some of the rights that a conservatee could potentially have in this petition when the process is happening. So they have the right to the notice of the petition. They have a right to oppose the petition. They have a right to be represented by an attorney. And if they can't afford an attorney, they are provided an attorney by the county. They have a right to be at the hearing. They sometimes have a right to a jury trial, although this is rare. Usually they're bench trials. And you may have friends of yours speak at the hearing on your behalf. So when it comes to terminating a conservatorship, in general, a general conservatorship will terminate at the death of the conservatee or by order of the court. If it's a general conservatorship and the conservator dies, it's usually a new one is appointed by the court. In a limited conservatorship, it can be terminated by the death of the conservator or the death of the conservatee, obviously, or a new order appointing a general conservator, which overrides a limited conservatorship, or an order from the court stating that's no longer necessary. And a conservatee can file a petition for this. What happens if you have a limited conservatorship and the conservator dies? So if you have only one conservator, there's no co-conservator, then the conservatorship will end when the conservator dies. If you're thinking about having a co-conservator on a conservatorship that you have, you should consider the relationship that that person has with the conservatee, the co-conservator's life circumstances, like are they able to take on the responsibility of being a conservator? Does that person know the system and the responsibilities of a conservator? We don't really cover this, but there are responsibilities when you're a conservator. And it can be a big job. So when it comes to a limited conservatorship, there are 7 powers that a conservator can have over a person who is conserved. And the first one is to determine the person's place of residence. They might have some or all of these powers, depending on what the court decides. The next power that they might have is access to the person's confidential records. The next one is to control or limit the person's right to marriage. And the next one is to control the right to a contract. And then to give consent for medical treatment. To control the person's social and sexual contacts and relations. Oops, yeah. And then the last power is to make decisions concerning the person's education. So those are the 7 powers that are available in a limited conservatorship. Limited conservatorships are what the majority of people that our clients have over them when they do have a conservatorship over them. It's what families mostly get when they just conserve an adult client. And the letters of conservatorship on the court will state which of these 7 powers the person has conserved on them. Oftentimes sometimes it's all of them, and oftentimes it's not. A couple of them, like the court might be not as excited about giving away, like the control of social and sexual contacts, for example. So here are some rights of the conservatee that they maintain while they're conserved. So even when they're conserved, they have the right to control their own salary, to make or change their will, to have children, to receive personal mail, to vote, unless this is specifically taken away by a judge, to be represented by an attorney, to ask for a new conservator, to ask for the conservatorship to end, which would be by petition. And then really all other rights that are not specifically granted to a conservator, you should assume that a person has retained. So when it comes to these seven powers that a conservator might have, here are some alternatives if you want to have some control over those 7 things without getting a conservatorship. So the first one has to do with where the client lives, their residence. You can support with fixing their residence or determining their residence through supported living services, SLS. They can, you can help them with getting supported living services or independent living services, ILS. These are services available to regional center clients. And then maybe within their circle of support, they choose to reside with someone in their circle of support, or provide or find rent assistance for them to live where they choose. They can get rent assistance from the regional center. They might get it through their benefits. And then there's also the possibility of them living in a facility that you can help the regional center find. And then the second power has to do with confidential records. There are a lot of ways to get someone's confidential records without having to get a conservatorship, right? So if you're thinking, I need a conservatorship because I need access to this person's records on a regular basis, You can do this through a durable power of attorney. You can also do this by having the client sign authorizations for release of information, ROIs, or HIPAA releases for medical records. So ROIs are for general information and HIPAA releases are for medical records. This is how we work. You know, we have to get people's records often, and that's how we do it, usually. And then you can also call or contact the agency you need the records with the client present or on the phone, you know, a three-way call, so you can get permission to access the records. The third power is marriage. If you want to support someone in making decisions around marriage, some options are that they go to counseling. Again, supported living services, SLS. SLS providers can help them make these decisions. Just generally parenting support, right? Just providing advice and companionship through parenting. And then there is marriage preparation. There's a lot of different types of marriage preparation. It could be counseling or financial planning. The fourth power is contracts, the right to contracts. Some alternatives to getting a conservatorship here, but still being able to support someone in their right to contract and control their finances is a representative payeeship. So you can be someone's representative payee, like through Social Security, and be able to get their documents and make decisions on their Social Security account without having to be a conservator. In fact, Social Security doesn't really even care if you're a conservator. You need to be a representative payee if you want to get all of the copies of the notices and supply documents to the Social Security office. You can also get services in your IPP to assist with money management. So there are, for example, there are organizations that do representative payeeships. If you don't feel like you have the capacity to do it, that's something that the regional center can help provide. And then there's other services that they can help with in terms of money management. And sometimes ILS or SLS workers will help with this as well. You can also get a special needs trust. Special needs trust is good because you can deposit money into it and it doesn't count against a person's benefits as a resource, as long as it was established correctly. And then lastly, you can get a power of attorney for finances. This is revocable, so the client can revoke it if they no longer want someone to have this power of attorney. So there are some additional protections when it comes to finances. One of them is called the contract law of rescission. And this is just essentially that that in contract law, there is what we call an equitable remedy, which allows a person who's in a contract to cancel the contract. And one of the reasons that they might do that is that the person who entered into the contract didn't have the capacity to do it. They didn't understand the contract. So if a client finds themselves in a contract that they didn't really mean to enter into and they were taken advantage of, or they didn't really have the capacity to enter into the contract can be ended, essentially. Another protection is that garnishments are protected. SSI and SSDI are protected from garnishments. So your SSI and SSDI payments are typically not payments that are going to be garnished from any sort of debt collector. There are like some few exceptions for this. For like taxes, if you owe taxes, I think alimony or child support can be taken from SSI, but typically you are protected from not having that money taken from you. Another option that if you want additional protections and just finance options is to create a CalAble account. And this is for eligible individuals, people with disabilities. If someone's eligible, that means that families, friends, employers, even the person themselves can contribute money into this account without it affecting their public disability benefits. Things like SSI and Medi-Cal. You can contribute up to $17,000 a year without it affecting your benefits. You need to have $25 to open the account. The maximum amount that you can hold in the account is $529,000. However, only the $100,000 is not counted as a resource for Social Security. So if you go over $100,000 in this account, every dollar above that counts as a resource. So if you have $100,001, then that $1 counts as a resource for Social Security. So you should just be aware if it will affect your benefits. This is a great option for people in California because we have strict limits on the resource guidelines for Social Security. But your account balance won't affect your eligibility for Medicaid or Medi-Cal. The next power that we have is medical treatment. So there are a lot of ways to help someone make medical decisions without being their conservator. First of all, the individual themselves can consent to healthcare services. You know, they can just consent to it themselves. That's an option. The closest available relative can also authorize healthcare, oftentimes. You can get a durable power of attorney for healthcare. It is revocable. There are some other alternatives for healthcare as well. You can get the regional center can provide authorization for medical, surgical, or dental care and can provide it directly to that medical provider. There can be court authorizations for specific operations. the whole sterilization thing on here is bizarre to me at this point, but this used to be a big legal issue for people in conservatorships that they were forcibly sterilized. So sterilizations require separate petitions. And then you have protections for emergency medical procedures. So when there's a need for an emergency medical procedure, the client doesn't need to give consent or doesn't even need to be capable of giving consent. The doctors can, doctors and dentists can take action without the consent. And then the next one is that ICF or SNF, which is intermediate care facilities, and wow, the S is blanking on my brain. Skilled nursing facilities can provide treatment and make treatment decisions for residents when a physician determines that the resident is unable to provide informed consent. So if somebody's living in one of these homes and a physician determines that the resident cannot provide informed consent, the home can provide the consent for the treatment. Okay, what is a durable power of attorney for healthcare? This is something that people often get and want to have. It allows you to appoint another person to make physical and mental health care decisions on your behalf, if you become incapable of making those decisions. You can get these forms from a stationery store, any store that sells pre-printed legal forms, an estate planning attorney. I mean, it's also a statutory form, so you can just look up the code. You can just Google the code and copy and paste it from the code itself. It's in the code, the regulation, the form is. We, however, will not give this form out to parents for our clients. Providing forms to parents is not our role as OCRA, but we will meet with the adult consumers who are going to be, you know, that need to consent to discuss their needs and help them complete the form. And then another power is sexual and social relationships. So again, if you want to help someone make these decisions, the best options are counseling services and supported living services. Did I skip one? Sorry. Okay, the last one is educational decisions. For this one, you can get a durable power of attorney. You can also make a transfer of educational decision-making authority. This is another form that's in the code. The client consents to this. So it's a really simple form. We actually have it on our website. Where when someone turns 18, they can say, I would like my decisions for my education made by this person. And then that person will be able to make the educational decisions for them. And then another option is an individual program plan, an IPP. So you can have these services listed out in the IPP even before the person turns 18. So those are some alternatives to those 7 powers, options that you can pursue if you want to have some ability to help a person make decisions on those 7 issues of their life without getting a conservatorship. This current slide is our contact information, our address, telephone number, fax number. And then if you are, this is the contact information for the Golden Gate Regional Center Office of Client Rights Advocacy. And our office serves San Francisco, San Mateo, and Marin. If you happen to be from a different county and not serviced by GGRC, and you want to connect to the right OCRA office, you can call that northern or southern line, and they will connect you to the correct office.
All right, thank you everyone for attending our training tonight. We appreciate you spending your evening with us and learning more about alternatives to conservatorships. A big thank you to Courtney for presenting all this information and to our interpreters for their hard work tonight. As Patricia mentioned, we will be sending out a follow-up email tomorrow with the presentation and materials, as well as the survey from the training. Okay, and that's it for us. So thank you everyone and have a good night.